Mm-hmm.
You're free to do your work, eh? And kufanya kazi yako.
Yeah, so that's him. Confirmed. Okay, and so this is the ruling. Sexual communication with a child, contrary to section 16A, 1, 2, and child pornography, contrary to section 16(1)B and G of the Sexual Offences Act. Now, after pleading not guilty to the charges, the prosecution, that is through Ms. Ndambiri and Ms. Matu, for the alleged victims, opposed his release on bond. In the objection to release on bond, they relied on an affidavit sworn by Detective Lawrence Okoth, attached to the Directorate of Criminal Investigations, Anti-Human Trafficking and Child Protection Unit. Now, the deponent of the affidavit averred that the accused is a 72-year-old Netherlands national holding a passport number BC2CKP538. He entered Kenya on 25th of October this year on a one-month tourist visa that's already expired. The accused and others not before court were arrested on 24th of November this year based on alleged intelligence that he was fleeing Kenya after commission of sexual-related crimes against children in Kisumu. At the time of arrest, the accused was waiting to board a KLM flight to Amsterdam. The accused spent time at JKIA police station, and on 27th of November this year, he appeared before JKIA law courts, where investigators obtained orders for 20 days pre-plea detention on 16th of December this year. Kibera High Court set the orders aside via the ruling delivered in miscellaneous application number E091 of this year. The deponent further averred that the accused is a flight risk, as he has no fixed place of abode. He has traveled to over 100 countries across the globe and established a lot of connections. He averred that if released, he may try to evade justice through the connections that he has. Now, Ms. Ndambiri, for the state, urged the court to deny him bond so as to safeguard the best interest of the minors. To to one of the victims, and he might therefore tamper with the safety of the children if released. So they urge the court to detain him in custody until investigations are concluded. Now, counsel appearing for the defense, these are Mrs. Owino, Mr. Wasaga. I have been corrected that it is Chisengi. Mr. Alwaka opposed the application for denial of bond. A summary of their submissions is that the accused is a 72-year-old citizen of Netherlands and married to a Kenyan lady. He is an engineer by profession. He runs charitable organizations in Kisumu and Eldoret that educates needy children. He therefore comes to Kenya quite often. Accused and his wife were arrested on 17th November this year by DCI Kisumu. Detectives confiscated his laptop and phones. They released him the same day after interrogation. Now, counsel argued that he did not run away from the country. He was arrested on 24th November this year and held in custody pending investigations. Counsel submitted that he was denied access to his advocates and family members. He suffered ill health while in police custody. The investigators took him to Kenyatta National Hospital, yet he had a medical card and had requested to be taken to Aga Khan Hospital. The advocates urged the court to release him on bond if appropriate, impose conditions that include detention of his passport and a caution against communicating with the witnesses. Now, I will start by setting the record straight on some of the issues raised by the prosecution, the defense counsel. One of them was an argument by Ms. Matu that there is need to detain the accused in custody for investigations to be concluded. My understanding of the affidavit sworn by one of the investigating officers is that investigations have been concluded, and all the state seeks is pre-trial detention. It is not an application for detention for purposes of completion of investigations. Such an application was heard and determined by JKIA law courts as well as the High Court at Kibera. Another issue I wish to dispose of at the outset is an averment by the defense counsel that the accused was denied access to legal representation and the right to quality health care. Now, this is an issue that should be addressed before a court dealing with compensation for violation of constitutional rights. The same is of no value in an application for bond. It is certainly not one of the factors considered when determining whether or not an arrested person will turn up for trial. Now, in determining this application, we rely on Article 49(1) of the Constitution that an arrested person has a right to be released on bond or bail on reasonable conditions pending a charge or trial, unless there are compelling reasons not to be released. I also rely on Section 123, Capital A of the Criminal Procedure Code that provides that subject to Article 49(1)(h) of the Constitution and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all relevant circumstances, and in particular, 1, the nature and seriousness of the offense, the character, antecedents, associations, and community ties of the accused person, the defendant's record in respect of the fulfillment of obligations under previous grants of bail, the strength of the evidence of his having committed the offense. 2, a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person has previously been granted bail and has failed to surrender to custody, and that if it released on bail, whether or not subject to conditions, it is likely that he would fail to surrender to custody, and lastly, should be kept in custody for his own protection. On case law, I rely on Republic versus Richard David Alden, reported in 2016 Electronic Kenya Law Reports, where the court held, and I quote, that I agree that a paramount issue for determination in considering an application for bail is whether the accused person will avail himself for trial if admitted to bail. I also agree that an accused person not being a citizen poses a challenge to the court, but that is not to say that non-citizens cannot enjoy the right to be released on bond as enshrined in our Constitution. Article 49(1)(h) is not of limited application, and the only condition set thereunder is a proof of compelling reasons to deny bail. The mere fact that the accused is not a Kenyan is not per se a ground to deny bail. Now, one of the issues raised by the states and the Victims' Council in seeking a denial of bond is that the accused person is a foreign national with no fixed place of abode in this country. In response to this point, the defense team told the court he runs charitable organizations in Kisumu and Eldoret, Apparently, there were no documents presented to support the contention. Defense counsel further stated that he has a Kenyan female partner. Again, there was no evidence to show for this, and in any event, this would not persuade the court to find that he thereby has a fixed place of residence in Kenya. It is not disputed that he's in this country on a tourist visa that seems to have expired while he was in custody. It is common ground he was arrested and about to leave the country. What I cannot determine at this stage of the proceedings is whether he was fleeing the country because of this case or he was leaving as his visa was due to expire. In the circumstances, the fear by the state that is a flight risk is not unfounded. That is not to say that the fact of being a foreigner should, without more, disentitle him to bond. It is possible to impose conditions to ensure that a foreign national with pending criminal charges does not jump bail. I note that in the affidavit, the investigator deposed that the accused has traveled to over 100 countries across the globe and established international networks that may enable him evade justice. But on a perusal of his passport, there were entry and exit stamps for Kenya and Tanzania only. And if there's any other evidence that he's a globetrotter, then it was not presented before the court for consideration during the bail application. Another concern heard by the state and the alleged victims' counsel is that he's likely to interfere with the case due to his relationship with some of the witnesses, coupled with the seriousness of the charges. Now, I hold the view that, yet again, the court is not limited in the conditions it can impose to ensure that there is non-interference with witnesses and that the accused remains within the Republic of Kenya during the pendency of the case. So in sum, I am not persuaded that the prosecution has established that there are compelling reasons to deny the accused person bond. I accordingly direct as follows that 1, the accused shall be released on a bond of 2 million with 2 Kenyan sureties of the same amount. 2, he shall deposit his passport in court for retention until the case is heard and determined or until further orders are issued by the court. 3, the accused is warned against contacting the witnesses or interfering with the case in any manner. And lastly, he shall avail himself and or cooperate with investigators as and when required. So that's, yeah. So are you ready to take a hearing date? Near January? January is okay? Tuesday myself? The second week of January has the second week has court number 6 and court number 5. So I can give it to court number 6. Please remind me, which day? Tuesdays. The Tuesday of 9th January. 9th of January. So is there need for mention for pre-trial? So this can be done after Christmas so that I fix it for here you have no option. If yes. Yeah. Okay. So mention for pre-trial. Yeah, I believe that. Okay. All right.
Hello, everybody. Good afternoon. ما ديشياته كبير.
Focus, focus. Focus up.